For those of you who don't know me, my name is Robert Kennedy. I am a partner in Holmes O'Malley Sexton, having been with the firm for the past 26 years. I am the head of defence and insurance litigation and contentious business. My brief is to talk to you very briefly about employers' liability in COVID-19 and how that is going to impact on us going forward. So bear in mind, although we are in the middle of a very significant emergency, your duties as employers to your employees continue on as before. So where do these duties come from and what are they? They come from two different places. The first is from government passed legislation, the secondly from judge or court made law of negligence. Dealing with the first aspect, the relevant legislation, there are two pieces here. The first of which is one that you will be very familiar with, and that is the Safety, Health and Welfare at Work Act of 2005. That act imposes a duty on employers to ensure, as far as is reasonably practicable, that the safety, health and welfare of their employees is safeguarded. Main responsibilities there are as they have always been: a safe workplace, a safe method of work, safe equipment, appropriate supervision and training, protective equipment where appropriate, and the provision and maintenance of facilities and arrangements for the welfare of employees at work. So as you will see, there are particular considerations with regard to the current pandemic that will apply there. Bear in mind, this legislation applies to employees working on site where they've always worked, but also to employees who are working from home now. Breaches can give rise to prosecution, but also give rise to civil actions for damages. We obviously haven't seen any of these as yet. There is a reported action, class action being taken in Austria in relation to COVID-19 infection. Who would have thought that the famously non-litigious Central Europeans would lead the charge over the litigious Irish when it comes to initiating actions for damages. The second piece of legislation is one that has been there for a very long time. It's the Health Act of 1947. This piece of legislation is actually where the Department of Health is getting the legal force behind our current restrictions and regulations. But there is a provision in that, section 43 of that 1947 Act, obviously in place long before the current pandemic, which allows for a person, an employee, to initiate civil proceedings for damages if the employer fails to take actions required pursuant to regulations, which results in the employee being infected with the disease. So again, it's an enabling provision there to allow an employee to sue an employer in circumstances where that employee becomes infected with COVID-19. Again, with the overarching provision that the employer must take reasonable care to ensure that that does not occur. The second area as to where this will arise is the general negligence provisions that have always been there. That is the court-made law, which says that the employer owes a common law duty of care to their employees under the law of negligence. So let's take a very, I suppose, simple example here. Say if employees are working in a manufacturing plant, the employer has a look at what needs to be done and provides extra hand washing and sanitizing facilities for the employees, but does not allow for relevant and proper social distancing, say, between workspaces or whatever, and suddenly there is an outbreak of COVID-19. The court would obviously consider, in the event that proceedings were brought in those circumstances, as to whether that employer had discharged their duty of care to the employees, and what they did, was it reasonable, and was it something that a prudent employer would have done in all the circumstances. There's obviously no simple answer to doing what is enough, but it will all come down to individual circumstances in each case. To quote the great Winston Churchill, he said many years ago again, however beautiful the strategy, you should occasionally look at the results. And that is precisely what the courts will do, employing the 2020 vision in looking back at what occurred to see as to whether what the employer did was reasonable or otherwise. There'll be very potentially serious consequences from a COVID-19 infection if the ultimate occurs and that employee, in fact, died as a result of an infection, then that could give rise to a very serious claim for wrongful death, which would be a suit that could run to many hundreds of thousands of euros. So as a prudent employer, what can you do? Obviously, at the moment, non-essential workers have been directed by the government to stay at home. Companies in both essential and non-essential sectors have now made that transition, in part or completely, to having their employees working from home, and that remains the position for the moment, to be reviewed next week. If your employees cannot work from home and they still must come to work, then there are some measures that you can adopt in order to ensure their safety. They are very fundamental issues like displaying the HSE posters and promoting good hand and respiratory hygiene. Redesign your workstations to ensure social distancing is maintained. Review existing risk assessments in light of the new working practices. Provide training based on any new procedures implemented, and supervise your employees to ensure that that training is being followed. So you should follow the guidelines as they have been set out, train your staff, document that training, and ensure that the training is being followed. Everything that you would normally do as a prudent employer, but with a particular focus when it comes to COVID-19. As a last thought, please remember nowadays, in the very strange world that we find ourselves living in, bedrooms and patio tables and kitchen worktops have now all become a somewhat unconventional workplace for many employees. The employer's duties are now actually extending into people's homes in a way that would never have occurred previously. So as an employer, it's important that you're aware of this, that you ensure that your employees who you do not have direct control over when they're working from home are taking appropriate breaks and have been provided with the necessary equipment to enable them to do their jobs from home. So bear that in mind. That is going to be undoubtedly a source of contention and litigation into the future. So I hope this has been useful for you.